then continue to view the session online if you wish. As a reminder, each side has 20 minutes to argue. If you are the appellant, keep in mind that you can reserve some of those 20 minutes for rebuttal. And if you'll let me know when the case gets started how much you want, I'll try to give you a heads up when you get to that point. Don't forget to mute your microphone when you're not at the podium, and unmute when you are. And just before we get started, I want to congratulate our Marshal and Clerk's offices for their very hard work and hours of practice to get us to this point. And so if there are screw ups during this session, it's their fault. So I'm only kidding, of course. So first case is, let me pull up my docket. First case is Gessel versus State. Good morning. You guys are the very first in the annals of the second DCA. You're going to be a very important footnote. So, Ms. Mogensen, I think you're up.
Good morning. Andrea Mogensen for Appellant David Gaze. I would like to reserve the maximum time that I may for rebuttal.
I usually give around 5 minutes or so.
Thank you. Really, the sole complaint in this appeal is the sufficiency of the affidavit supporting the search warrant permitting a search of Mr. Gazel's residence. If I may, I would like to start the argument with a quote from District Judge Rakoff from United States versus Correas, a Second Circuit case. Child pornography is so repulsive a crime that those entrusted to root it out may, in their zeal, be tempted to bend or even break the rules. If they do so, however, they endanger all of us. And I would suggest in this case that in their zeal, a new detective to the Crimes Against Children unit did not follow the rules. And for that reason, the evidence against Mr. Gazel should have been suppressed. The standard of review is great deference to the trial court judge, but this court should not defer to the trial court judge if the affidavit is lacking in a substantial basis for probable cause. And we suggest that it is so lacking. Functionally, the affidavit itself alleges a single image of debatable lawfulness in a conclusory fashion. We received a tip of child pornography 5 months ago from a source that previously was inaccurate in accusing the same person of possession of child pornography. That's the functional allegations in the affidavit. We think that suppression is required for several reasons. One, staleness, not just the issue that 5 months had passed between the tip coming from the National Center for Missing Explosion via chat step. That 5 months alone is not a sufficient basis for suppression, but the 5 months itself did not have any additional facts to suggest, the affidavit didn't have any additional facts to suggest that that the 5 month delay, after the 5 month delay, we would expect to find contraband in the location to be searched.
Although didn't the affidavit point out that even if the, and I'm relying on memory here, that even if the image had been deleted from the computer, that it's, you know, it was still on there, that a forensic person could find it?
Well, this is sort of akin to the, it did. This is sort of akin to the Burnett case, the second district case from 2003 cited in the brief. The image under discussion was already possessed by law enforcement officers. So for them to go in on a search warrant to obtain that same image, it was not really essential. The question, and of course, any images, any data from a computer, provided that they collect the computer containing the images, can be forensically mined. The question is, to what facts were alleged in the affidavit that suggested that if we went to 2895 Miralota Boulevard in Sarasota, Florida, that we would A, find the device under discussion, and B, find additional images, because the search warrant wasn't limited to collecting that image. It was to collect other images, all images, to go through all the data, basically to root through the personality that's protected by the Fourth Amendment. And the affidavit may have been sufficient if a sufficiently experienced detective would have alleged facts that suggested, this is why we think that device will still be there. This is why we think that image would still be there. These are the habits of child pornographers, and these are the reasons we think this person was a child pornographer. There was nothing along any of those lines in the affidavit, and Burnett suggests that's required. In the Burnett case, they had collected a video recorder and had a video that basically supported lewd and lascivious molestation allegations, and the detectives, having already been to the house, wanted to search the room for additional pornography. And this court said, no, you can't put conclusory statements in there. You need some type of expert or scientific information in the affidavit or factual foundation for the proposition that after the passage of time, but even in Burnett, there wasn't a passage of time, that additional images would be found.
Well, with regard to the location of the device, it had an IP address that was identified with a certain physical address. And you say there weren't sufficient allegations to show that that particular computer would still be at that address. Give me an example of the allegations, because typically that's all you're going to really get. You're going to get an IP address that's associated with a physical address, and that's a reasonable thing for police to believe that that computer is still there. So give me the type of allegations that you think should have been in this affidavit that would solve that problem.
Well, the record suggests from the detectives doing this investigation that they not only have the ability, but traditionally do monitor the traffic from that IP address before and subsequent to the objectionable image. I mean, first and foremost, the objectionable image, I don't think was proven, but let's just assume for argument's sake that it was, that there was actual sexual activity depicted and alleged to be depicted in that image. He did say that the chat step, traffic can be monitored, can be mined. They can look for activity of passing images, unlawful images to and from other users. That suggests the pattern of criminality that's necessary to support a search warrant. Both of the detectives, the more experienced and the novice detective, both testified that a person can unknowingly possess a single image. And in the traffic,
but your argument about unknowingly possess, they don't have to get the warrant based on his knowing possession. It seems to me that if the image is child pornography, a crime has been committed, and that is evidence that a crime has been committed, and they're looking to find it at that location. It doesn't necessarily mean that they have to allege a basis for assuming that he knew he had, correct?
Well, what they have to allege is a sufficient basis to believe there's a commission element and a nexus element.
Right, but I mean, the crime doesn't have to have been committed by him.
True, but knowing possession is more strongly suggested by detectives uncovering, as they do in most other cases.
But this wasn't just mere possession. This was uploaded. It was actually uploaded. It's not something that he was engaged in some peer-to-peer sharing and he just said, give me everything you've got. And it was, maybe inadvertently downloaded. It was uploaded. So doesn't that more strongly suggest knowing possession?
I think that's a distinction without a difference, because we're not, just as you can download a batch of items and not know what is in it, you can upload a batch of items and not know what was in it. If you are unknowingly in possession of an image, I mean, who here has not sent the wrong attachment on an email before? So I don't think
the point, Ms. Mogerson, though, is that someone took this image, took this photograph. It was in some way transmitted, perhaps not created by your client, but this image was created and it was uploaded. So therefore, it was possessed by someone, and it was clearly knowingly possessed. by someone. Doesn't have to be your client to get the search warrant. Search warrant just has to create a probable cause to believe that they will find evidence of a crime in that location, not necessarily a crime committed by your client, correct?
Well, as I pointed out in my initial brief, the knowing possession is that double scienter requirement. You have to know you possess it, but you have to know the nature of the image.
To convict someone of the crime, but to create probable cause that the evidence of a crime will be found at that location. They don't have to allege that he committed the crime.
Well, one of the things that the jurisprudence has sort of not kept up with technologically is that an IP address our devices are becoming increasingly mobile. We have a desktop, we have an iPad, we have a cell phone, we have visitors with those things. And in the absence of some other fact, at least one corroborative fact to suggest that the nexus requirement would be met on a single image. I mean, this is why I put the trash pull jurisprudence in there, because that seems to be more akin to what we have here. When we have visitors with iPads, when our children have them, when our teenage children have them, to permit entry into someone's home based on a single image without knowing any of the surrounding facts or circumstances by which that image was associated with that address, it would seem that you need some type of pattern of criminality.
And you totally disregard the earlier image because it technically did not qualify as child pornography. You think that it was not even relevant and shouldn't have been in the affidavit?
I think that it would chill First Amendment protected speech if lawful First Amendment protected images could be used to support probable cause for criminality. And that's not necessarily just my thinking. That's what the United States Fourth Amendment jurisprudence suggests. And I believe it's page 40 of my initial brief in footnote 2, is that if we, that courts can't take First Amendment protected lawful materials and use it to support probable cause without chilling First Amendment protected speech. So I think, and the worst part,
there was speech that wasn't protected by the First Amendment, and that was the second image that gave rise to this affidavit that they had probable cause to believe was child pornography. So, but you don't think even as relevant to that determination that they could have considered the earlier image?
No, because if that, I'm sorry, there's a lag. I thought you were finished.
No,
so I'm sorry if I interrupted. I think that if the first of all, the offensive part about the 2016 image is that it was portrayed in the affidavit as being child pornography when it had been verified by 2 agencies as being a lawful image. That's probably the biggest problem with putting that in the affidavit, is it's misleading. It's frankly, it says the National Center for Missing and Exploited Children had identified this image as child pornography. And one, we know the National Center for Missing and Exploited Children does not so identify. Their tips come with the cautionary information that they don't actually review them. They have a bots crawling the internet for hash values and refer things electronically. This is artificial intelligence. This is not human intelligence and has not been reviewed. So that's misleading.
They actually described the image also, correct? You didn't just, Detective Ellis didn't just say there was an image of child pornography, and he didn't actually describe the image as an image of child pornography. He described the image, correct?
Correct.
And the trial judge specifically said, I don't find that misleading. He didn't say it was child pornography, and he gave a description of the image. So I don't find it misleading, correct?
That's what the trial judge said. That is correct.
But contrast that with Ms. Mugison with the detective's description of the image at issue in this case in the warrant.
Well, that's what was troubling in my view of the affidavit. If the detective had the ability, and the detective did, label the 2016 image as child pornography identified by NCMEC and then describe it in detail, but then the image that truly lies on support his probable cause, he just says, I verified as child pornography, when it's an image of simple nudity, of a child's simple nudity on a beach towel without describing that equally, is misleading. It is the magistrate who should make a decision whether the facts support probable cause. It should not be.
I mean, isn't it even even a question of whether it's misleading, isn't it just basically a conclusory statement?
Yes, sir.
It doesn't
And
describe why it's pornographic.
yes, sir. And that is troubling because, as we know from Illinois v. Gates, the magistrate judge is not just to ratify the conclusions of the detective, they're to make an independent probable cause determination and hold law enforcement officers' feet to the Fourth Amendment fire to ensure that people's homes and thresholds are not being invaded with absent probable cause. And because it is conclusory and lacking in and because it's a image, I think it's very, very important that this detective did not have the training and experience necessary to make that determination. When you couple that with the conclusory statement, it's especially troubling. It turns out
his training, as we know from his testimony, was essentially all tech-based. But I'm not sure. If you read his description of his background in the probable cause affidavit, you would necessarily know that he basically had no experience as a detective in this area.
It would appear that the affidavit was untruthful with regard to his participation in search warrants, because this is the first one he drafted. What they should have done is they should have had the more experienced detective as a co-affiant and put that person's experience in there, but they did not do that. And one of the big failures in this case is of the trial court judge to remain within the four corners of that affidavit as he's required to do.
But even though this was that detective's first affidavit and search warrant, as I understood, from what I read, that he had been involved in others before. Did I misunderstand that?
This detective had done applications in narcotics. He wrote in his summary of his experience that he had participated in numerous search warrants involving child pornography. But the reality, what he testified to at the hearing, was this was his very first one.
And he was
I understand it was his first one, but he said he participated in others. And having done this as a circuit judge, I understand how this works. They seldom work individually, they work in teams. And when they show up in the middle of the night at your house and want you to sign one of these search warrants, there's 3 or 4 of them there. Okay, so I'm very accustomed to that practice. And whether he was or was not, the author of those previous ones doesn't mean a whole lot to me if he's been involved in them. And I understood that was the case. And you've made a big deal out of it. This was the first one he engineered by himself. But if he's been involved in others in the past, that wouldn't trouble me that this was the first one he signed.
Well, he was moved to the unit on some undisclosed date in January, and I can only imagine that if it was January 1st, we would know. But at some point in January of 2018, he was moved to the unit. On February 9th, he drafted this affidavit. So his participation could be a maximum of like 40 days and a minimum of like 10.
But he was involved in search warrants other than of this particular type. You said he was involved in other.
But I don't think that. But that in and of itself isn't what we're suggesting should carry the day. The fact that he was inexperienced in this unit and made the conclusory determination in the absence of any training as to what should support that decision making, and those factors taken together suggested defective.
Okay, you're down to 5 minutes there, Ms. Morganson, and you do with them what you wish.
Okay, I think one area that we did not nearly enough is the consideration of all the testimony outside of the 4 corners of the application. The application itself is insufficient, and they attempted to remedy that with testimonial evidence from a more experienced detective. I think that the trial court was duty bound to follow the instructions from this court and the United States courts as far as the limits of the Fourth Amendment. It would lead to an absurd result if if magistrate judges could accept insufficient warrants. And this one is insufficient because there's no non-speculative evidence to suggest that more contraband would be found in this residence. And we must rely on the things that are believed to be known about child pornographers, they have to be alleged in the warrant. You can't not allege them in the warrant. The detective with sufficient training experience needs to allege with specificity, and that's Ignat, United States versus Ignat, must allege in that affidavit. This is what child pornographers, particular case, why this particular house, why this particular address is expected to have child pornography. We can't find child pornography so repulsive that anything will get you into the thresholds of our homes. It's the Fourth Amendment is not different in child pornography cases than it is in other cases. And I think that a pattern of criminality still needs to be shown. Scientific or expert information still needs to be included in the affidavit, and it needs to come from someone who has the training and experience to put that information in an affidavit. And until a detective has that, they need to be a co-affiant with somebody who does. There needs to be some explanation for why the informant in this case, the chat step through both of those were electronic referrals to law enforcement. And the fact that that exact same platform wrongfully identified and wrongfully accused Mr. Gazel of previously possessing child pornography, and it was verified to be not true, seems that it should be meaningful in this case. It should be meaningful that because these bots that are crawling the web are casting a broad net for all 50 states without regard to the limitations, the First Amendment limitations of what is pornographic and what is not, state by state. So it is especially incumbent upon law enforcement officers and trial courts to ensure that the proper steps are followed to make sure that there's sufficient factual foundations and not just go on those bare allegations.
Ms. Mogeson, you're down to a minute, so if you want to save some rebuttal, you probably ought to wrap up.
Yes, I do.
Thank you. Right, Ms. Klein, you need to unmute. State rests on its brief. No, I'm teasing. We'll pause for a moment.
Thank you. Technical difficulties.
Yeah, I get it. That's the only one we have today. We'll be really lucky, I think.
May it please the court, Catherine Klein, Assistant Attorney General for the state in this proceeding. First, I'd like to remind us about the law of a magistrate and probable cause and a search warrant. And in determining whether there's probable cause to support a search warrant, the issuing magistrate makes a practical, common sense determination, given all the circumstances set forth in the affidavit, that there is a fair probability that contraband or evidence of a crime will be found in a particular place. And the state submits that the affidavit in this case was sufficient to provide probable cause. The facts set forth in the affidavit by Detective Ellis provided probable cause that the image of child pornography significantly uploaded from his computer or some device in his home from his IP address had been uploaded to ChatStep 5 months earlier. There's probable cause that it would still be found on the device in Pellett's home. And well, the magistrate.
Ms. Klein,
I'm concerned. I'm sorry.
Go ahead, Judge North.
I'm concerned with his very conclusory assertion that this was child pornography without describing it at all. And if you look at his affidavit, he has no training in that area. All of his training is in technology. And one suspects, although he doesn't say it, that his participation in these types of cases previously had to do with, the technology and, searching computers and pulling images off. But that doesn't necessarily, in fact, it doesn't at all qualify him to assert that a particular image is pornography. It's certainly not reflected in the affidavit.
The affidavit, you're correct, it says the image that is the object of this search warrant. He says that he observed it and determined that it was child pornography. It doesn't.
He doesn't describe it beyond that.
No, he does not describe that particular
He
image
doesn't
beyond
describe
that.
at all what his qualifications are for determining whether something
His experience. Oh, excuse me.
His experience as a tech pulling images off computers.
He was experienced in doing digital forensics on peer-to-peer. He described peer-to-peer sharing networks, which are a little different than this case, where the subjects share stuff on the computer networks. He said he had participated in prior searches, as was discussed in the previous argument. He had participated. He had not drafted a warrant on his own, but he had participated in those searches. So he does have some experience in the realm of investigating child pornography. He had been brought onto this.
He has no training in it.
He has training. If we get into the later portions that have to do with misrepresentation, Detective Kay described that this is more of an on-the-job sort of training. This is a small unit where they all work together, and that he had been pulled into the unit. He had worked with them before, but officially became part of the unit. I guess he'd worked with them on the tech side,
Right.
and officially became part of the unit recently before this.
I mean, if you read the affidavit, basically his only experience that relates to this area is on the tech side.
It seems to be pretty much, other than his participation in executing other search warrants, not drafting. I'm assuming that he's saying I participated in 5 to 10 of these, but this was the first one that I drafted. So he does have experience in serving these warrants.
When they show up, as Judge Morris points out, when they show up for these things, they bring, there are several people who come, and particularly when you're talking about an uploaded image, you've got a tech person with you, correct?
Yes.
I mean, again, I'm speculating, but based on the evidence in the affidavit, it would seem to me that would have been his role, because that would have been his only qualification for being in the team that served the search warrant.
And he did swear in this affidavit that he observed it and that the image was child pornography.
And the image was, and he concluded as a matter of law that this image was child pornography, but he didn't bother to describe it. Now, the image that had been previously determined not to be pornography, he described.
And he said that he described that image because he found it and he wanted to, his description went to the fact that that image wasn't child pornography because it was not a lewd and lascivious exhibition. The child's genitalia was not exposed in that.
But he didn't, and so the magistrate was supposed to infer by his declaration that this image was pornography. The magistrate was to infer that
he testifies that, and I think what's happening here is that he's writing to his audience, and the audience being judges, state attorneys, and people who are familiar with this type of crime, and that they would know from that description that wasn't child pornography, and that why that particular image wasn't pursued.
Right, but why wouldn't he put facts in the affidavit from which someone could determine that the image was pornography? He didn't put anything in there to show that it was.
I can't speculate as to why. I don't know if it was an oversight, an omission.
And really, actually, in terms of the sufficiency of the affidavit, it doesn't make any difference. Why?
I don't think it because you have to look at this affidavit in its entirety. You have to look at all the circumstances, and under all the circumstances of the affidavit, his description of his experience with the computer forensics, and the determination that this was child pornography. I mean, a lay person can make a determination that something is child pornography. He does not need a certificate in child pornography viewing or something of that effect.
You do need some facts upon which to base that determination, and they just weren't in this affidavit, were they? I mean, the only thing you have in this affidavit is you have one prior transmission that was determined not to be pornography, and you have someone who has just no experience, or at least does not describe any experience determining whether something is pornography, right? His prior experiences as a tech who's pulling images off computers, but he's pulling images off computers. It's not his job to decide whether they're pornography, correct? So, you know, all I see is someone who says, oh, that's pornography, but I don't see any basis for concluding that he knew why that was.
Admittedly, there's no description of that image in the affidavit, so that
and the magistrate couldn't make that determination based on facts in this affidavit.
I guess the magistrate is relying on a sworn law enforcement officer's sworn statement that image did constitute child pornography.
Nice.
And later on in the hearing, there is testimony that he consulted with his supervisor, the senior detective on this unit.
But that wasn't in the affidavit.
What? No, that's
I
not.
go to Ms. Bogeson's point that this is a fact beyond the four corners of the application.
Well, that would go to her further allegations that there was intentional deception or omissions that would defeat this warrant. And so that for those reasons, admittedly, some information outside the four corners of the affidavit came in, but that was in response to those allegations of intentional and reckless omission of this information. And the state would submit that did not defeat the warrant. And if you'd added the description, it only would have made the affidavit stronger.
It might have made it, or arguably might have made it sufficient.
Would have made it stronger. And also, again, I'd like to remind, we're talking about the totality of the circumstances of the affidavit, providing a fair probability that that this image would be found on this computer, a device in this house where the IP address had been traced to, and that it would still be there due to the nature of like computer storage and digital files. You may think you deleted something and it could be there months, years later. So as far as that is concerned, the affidavit is sufficient. And I also like, there was a comment that this picture was simple nudity, and this picture is not simple nudity. And the trial court in this, again, later in the hearing, determined, the trial court viewed the image and went through the dosed factors and determined that this was a lewd and lascivious exhibition. The girl is on her knees on a towel in front of a brick wall. The pose is not natural. The focus is on her genitalia, and the trial court concluded that this was a lewd exhibition, which is sexual conduct and satisfies requirements under the statute. And if this court has no further questions from me, I'll rest on my brief for the rest. I can't hear you.
I said, usually at this point, I would look to my left or my right to see if I had any more questions, but I guess
you need like a hand sign or something.
There you are.
Okay.
Oh, this little thing, I just wear this around the house all the time. Thank you, Ms. Klein.
Thank you.
Ms. Morganson, you have what, about a minute, I think.
I think that because there are dosed factors to consider in whether or not an image is pornographic would suggest what has been held in Felton v. Pensacola, that just using law enforcement officers' good judgment to determine what is and what is not First Amendment protected and what is and is not unlawful creates both First Amendment problems and due process problems. And I think the court has keyed in on the conclusory statement of we don't know if this law enforcement officer, if this detective was aware of the dose factors or considered the dose factors, but the fact that they exist and that this was not just images described in affidavits typically go like this. We've received, 400 images, 97 of them displayed bondage or bestiality or simulated sex or something. Just, it doesn't have to be specific as it was with regard to the 2016 image, but it should at a minimum inform the magistrate what was depicted, because had a magistrate known that it was a naked child on a beach towel, the dose factors may have come into play, and that magistrate judge should have required the affiant to consider the dose factors, to give them the factual foundation for that before authorizing entry into a home. The chief evil the Fourth Amendment is meant to protect is the home.
Muted.
Your time is up.
Okay, thank you.
Thank you both very much. And I think overall this one went quite well. So we appreciate it.
Thank
the
you.
Next case will be, if I can find it. Next case is Lake Carroll Court Property Owners Association versus Baker.